5 seconds to go. Start. Therefore, it is clear that the provisions of the CRPC are applicable to all proceedings under the Act, including proceedings before the special court, except to the extent they are specifically excluded. Stop. Hence, Section 71 of the PMLA providing an overriding effect, has to be construed in tune with Section 46(1) and Section 65. Stop. Para. Having taken note of the relevant provisions of the PMLA, which have a bearing upon the jurisdiction of the special court, let us now turn our attention to some of the provisions of the CRPC, which deal with the question of territorial jurisdiction. Stop. Para. As pointed out by this court in Kaushik Chatterjee versus State of Haryana and others, the question of territorial jurisdiction in criminal cases revolves around, place of commission of the offence, or place where the consequence of an act, both of which constitute an offence, ensues, or place where the accused was found, or place where the victim was found, or place where the property in respect of which the offence was committed, was found, or place where the property forming the subject matter of an offence was required to be returned or accounted for, etc., according as the case may be. Stop. Para. As articulated in Kaushik Chatterjee Supra, the jurisdiction of a civil court is limited by territorial as well as pecuniary limits, but the jurisdiction of a criminal court is determined by the offence, and or the offender. Stop. Para. The discussion on the question of territorial jurisdiction in terms of the provisions of the CRPC can be cut short by extracting the principles culled out in paragraphs 19 to 21 of the decision in Kaushik Chatterjee. Stop. They read as follows: Para. Chapter 8 of the Code of Criminal Procedure, 1973 contains provisions relating to jurisdiction of criminal courts in inquiries and trials. Stop. The code maintains a distinction between inquiry, investigation, and trial. Stop. The words inquiry and investigation are defined respectively, in clauses G and H of section 2 of the code. Stop. Para. The principles laid down in sections 177 to 184 of the code contained in chapter 8 regarding the jurisdiction of criminal courts in inquiries and trials can be summarized in simple terms as follows: Para. Every offence should ordinarily be inquired into and tried by a court within whose local jurisdiction it was committed. Stop. This rule is found in section 177. Stop. The expression local jurisdiction found in section 177 is defined in section 2J to mean in relation to a court or magistrate, means the local area within which the court or magistrate may exercise all or any of its or his powers under the code. Stop. Para. In case of uncertainty about the place in which, among the several local areas, an offence was committed, the court having jurisdiction over any of such local areas may inquire into or try such an offence. Stop. Para. Where an offence is committed partly in one area and partly in another, it may be inquired into or tried by a court having jurisdiction over any of such local areas. Stop.